Ma'am has a wide range of experiences when it comes to the corporate and commercial law. And I think I've been awe of her profile ever since I came across it. And I've always been following her on LinkedIn and always being up to date with whatever sessions and everything that she keeps doing in this area. I think it's extremely intriguing. Thank you so much, ma'am, for taking out time on a Saturday evening despite your hectic schedule. Ma'am has also been on the Forbes Legal Power List 2021 for top individual lawyer for corporate, commercial, e-commerce, fintech, startup, technology, franchising, licensing, IPR, and M&A. And that's extremely wonderful. And she's an alumna of Campus Law Center itself. She completed her LLB degree from our college. And we are very happy to welcome you here, ma'am. We can start with the session. And if Ruchita ma'am would like to add in a line or two, that would be great as well. Sure.
No, I'm just very happy. First of all, formally, Achint, I would like to welcome you on behalf of Team PAC and definitely on behalf of Team Campus Law Center. And as I told you earlier, I would really be happy and I'm looking forward to have interactions with you further. So next time, whenever we have such programs, we plan it offline. We can have full day workshops actually.
Sure. An
But yes,
absolute
and
pleasure.
absolutely. And I'm sure the students have lots to learn from today's session. So I will not take much time. And I think we can start with the session as soon as possible.
Thank you. Thanks, Ruchita ma'am, and thanks, Kujatika, for a very warm welcome. You've been very gracious with your words. I think, in the interest of time, since there are quite a few topics, if you could just start presenting the screen. And I would request all of you to keep your mobile phones handy because I've got quite a few questions to ensure that there's ample participation from each of you via the Mentimeter, and you may want to log into menti.com. But just to begin, very good evening and a warm afternoon to all of you today. As has been mentioned, I'm Achint Kaur. I'm working in the corporate and commercial department of Khaitan and Co. I have almost 2 decades of experience, and I'll be dealing with the roadmap for a successful corporate lawyer, commercial transactions, the art of drafting, negotiation, and management skills. As you're aware, each of these are extremely comprehensive topics in themselves. So I have divided my presentation broadly into four heads, one being the roadmap or the tips for successful corporate lawyer commercial transactions, then being drafting, third being negotiations, and finally the management or leadership skills. Next slide, please. As we deal with the key skills that are required. Next slide, please. I would want to, before we delve into further details, I would want each of you to look at Stephen Covey's the 7 habits of highly effective people. This is extremely critical, as you would see that I understand you all being fledglings who are just opening up your wings to join the profession. These are points, and this presentation will basically equip you with the tips and things that you should know and inculcate in order to be successful. Uh, to jump into the topic, the first this first habit of a highly effective person would be to be proactive. What that basically means is you must have initiative and be responsible for your own life's goals. Always keep the end in mind. You need to visualize whatever your potential aims and missions are. I would want each of you to take pen and paper. Maybe after this session, you must jot down your personal mission statement, and how that would help is and what are the ingredients I will tell you now. You need to ensure that your personal mission statement covers not only what you want to be, either as a person or from a character perspective. The second would be what you want to do with respect to the contributions and achievements that you want to have in life. And finally, the values that you would want to intend to inculcate as you go about achieving these two tasks. The third point would be putting first things first. This is all about prioritizing and organizing. We always understand that in life, irrespective of whether it is at the professional or personal front, organization and planning ahead is extremely important. Prioritize first things first. And the next point would be of thinking win-win. This is going to help not only from your personal growth perspective, but in any negotiation that or any drafts that you're preparing. Always work towards a collaborative and in a cooperative manner rather than a competitive arena. Always understand that eventually, in the long run, you're not in any race with anyone else but yourself. Every person's journey is unique, and thus the only people who work in a collaborative and cooperative manner are the ones who will integrate and synergize together to emerge as a winner of tomorrow. You have to try and, as the next habit, inculcate the habit of understanding and empathy. Several times what happens is that people are not necessarily listening with the intent to understand, but only waiting for an opportunity to reply. And that is just not how we would want our highly effective people of Campus Law Center to grow up to be. As I mentioned, synergizing is extremely important. A collaborative work environment will be fruitful for all parties involved going forward. In such a case scenario, whenever you're dealing with human beings, whether it is your colleagues, your seniors, or those who are junior to you, always keep empathy by your side. These are the only tools which will help you build trust and respect in any relationship and in any engagement. These are the key tips that you should bear in mind. And finally, since all of us want a longevity in our career of at least 2, 3, or 4, 5 decades, therefore, that is feasible only when we learn to renew our cells to sharpen our saw. Now, sharpening our saw is not necessarily linked with only the knowledge that we gain and want to keep ourselves up to date with, but also from a physical, social, emotional, or even a spiritual and mental perspective. You must take a step back, divide your day so that you can balance it, each of these areas, and only then, once you have done that, would you be renewed for the future. Next slide, please. Something which you all already know is the logical progression towards the corporate or commercial transactions lawyer. I'm sure several of you have already undertaken whether one or several internships. In addition, you may be thinking of applying for masters or other certification courses, or may have already got some certification course in your pocket during the course of these 3 years. Finally, you would be taking the bar exam and enrolling yourself by way of the registration and securing a job. But take one step back and stop. Are these alone going to be sufficient to ensure success in your career? No, not really. And that's exactly why we are having this session here, to equip you with those skills which would help you in good stead in your career. Next slide, please. Before we go into the details of the skills that are required for a corporate or a transactions lawyer, I would want you to look at different areas. Although I have only mentioned about 15 of them on the screen due to paucity of space, but I would want you to go back and think for yourself, which are the areas of law that you may want to specialize in. And please do not feel constrained to specialize only in one or two, because even though finally you may be working in one or two areas, it's always good. And I would say it is a necessary requirement of today that you should have knowledge of almost every facet. That's why take that step back and try and first decide what is the area that you would want to work and are comfortable with. So even when we're talking about a corporates or a transactions lawyer, you may have M&A, but along with M&A and due diligence that you have to undertake, corporate commercial contracts or even the general corporate advisory are something that would go hand in hand as part of our team. In addition, we have the regulatory facets, we have data protection, we have IP that you must know. So I would request each of you to do that introspection before you go forward. Yes, I see a hand raised.
Good evening, ma'am. I'm Ananya
Good
Arora.
evening. Hi, Ananya.
Ma'am, it's a really interesting session. First, I wanted to say that, and I wanted some information about the media sector.
Sure.
Telecommunication. Actually, ma'am, I want to be a corporate lawyer, but I don't know if media law thing is a part of the corporate or is it a separate field in itself of law, and what is the growth of it?
See, I'll tell you as we are proceeding to the next slides. Very good question, Ananya, because there are different topics that you see on the screen. They may be just a few of them that I've mentioned. We in our firm also have a TMT or a telecom team, telecom media and telecommunication team, which is there. Even though that may be a very small team as compared to the corporate team, but yes, if you want to specialize in that area, that is the next big thing. And I would also be dealing with some of the points when we're talking about the latest developments that we need to bear in mind. Whether it's digitization or AI, these are things which you must be aware of, irrespective of whether you want to finally specialize only in that. So feel free, there is a separate specialization which is available. Obviously, ours being a full service law firm, we have each and every topic, not only those which are enlisted before you, but there are almost 70 different areas and more, because we have almost 700 specialized experience lists. So you can imagine, as law progresses with every facet that needs to be dealt with, there is an experience that is required. So there is a future. While obviously I would, as from a recommendation perspective, I would say keep that handy, and you should at an initial stage try and broaden your knowledge, because as you go forward you may want to specialize in lesser things, but at an initial stage you may want to learn as much as you can. So at that stage, while you keep your specialization of TMT or media, you can always keep corporate as your main area with M&As and due diligence, and along with that keep media or digital space as something that is of interest to you, because that's also something that each of us does. Thanks. So going to the next slide, I would want each of you to open menti.com on your phone and put the code 19274196 and answer the question that is there before you. Just understand what are the skills we would want to know. What do you understand as the specific skills that a corporate and commercial transactions lawyer would require? Please don't feel scared that this is a correct or a wrong answer, because there are no wrong answers ever in life. It's all about a learning process. And while we may think that there are a few, there could be several more. So feel free to input whatever comes to your mind.
Ma'am, could you please repeat the code?
19274196.
Thank you.
Welcome. It's there on the screen as well for anyone who has missed out. Log on to menti.com and use the code 19274196. Great. We've got the first answer in of objectivity, communication, Typing, formatting, great. Knowledge, negotiation skills. Deep understanding of law, dealing with people, business awareness. Great. We've got quite a few answers. I think we're getting some more. Okay, in the interest of time, since we have 5 such sessions, I'm sure you've got a hang of it. Let's proceed to the next. So you all have given the correct answers here. Let's delve in detail on the points that are required or the skills that are required for a corporate and commercial transactions lawyer. Each of the skills that you've mentioned and several more are going to be basic ingredients. While I have only mentioned about 10 of them, you have to understand that at the core of a roadmap for success is your unquenchable thirst for learning, knowledge, and growth, both professionally as well as personally, to better yourself each day. And that can happen only when you keep sharpening your saw as with respect to the knowledge that you gain and update each day. While I'll be dealing with negotiation skills and drafting separately, and also dealing with knowing your audience as part of the drafting exercise that we need to do, I would now want to keep in mind that you must, like someone had rightly mentioned, have knowledge not only of Companies Act, but of FEMA, RBI compliances, the DPIIT circulars, or even competition and IP. These are all intertwined, which you must have knowledge of. When we're talking about a lawyer is one who would not only be able to build a trust with the client because of their communication skills, but is known to have critical analytical skills. So this is a skill set that you must have an eye for the detail. Several times when people are preparing or getting into the profession, they don't value research as much as maybe arguing in court or final drafting and so on and so forth. But always understand that research, planning, or even the due diligence are only the initial basic blocks without which no building can be constructed. So these are very critical and essential ingredients, and the quality of your drafting or even your pleadings, argument, negotiation will all depend upon the research and planning that you put into it. Another point is that several times people forget that ethics must go hand in hand with your practice. Several times the answers that I would hear is that the client is always right and whatever work we get, we must take that. But always understand there are scenarios where people may take up a matter just because the client has said so. But what a client actually appreciates is if you can be transparent and let them know that these are the chances of success. These are the things which they have not complied with as per law, and therefore these are the outcome that you would foresee. When they see that whether it is confidentiality or any other ethics that you are maintaining as being extremely critical, they will also trust you and respect you as a professional much more than someone who simply takes up a case because a high fee is being offered. Now, let's go to the next stage, and I will be dealing with other topics more in detail in the subsequent slides. When you talk about the emerging sector, like Ananya had just now raised a question on, you would notice that there are several sectors, whether it is renewables, electric energies, electric vehicles, or even the digital space, e-com, which has developed and boomed in the last few years much more as compared to the previous years. You can see that in this India's 2023 budget as well, there are several sustainable initiatives. And not only is the e-com sector due to reach $200 billion by 2027, but the government as well as the world over, even the World Economic Forum has in this year talked about cooperation in a fragmented world being its theme. And it is in this globalized business economy that coexistence and interdependence is going to be extremely critical. Only when we have good corporate governance, sustainable initiatives, and a focus on a more digital yet ethical ways of working can we proceed forward. Next slide, please. While as part of corporate governance, you would notice that our budget had specifically spoken about transparency and being accountable, because these are the linchpin for building a high performance culture. We have a clear focus on the digitization as well as making AI in India and making AI work for India. Whether it is the 100 5G labs, centers of excellence, or even the national digital infrastructure that is built, there is the renewed focus on the digital space. There is also a focus on ESG and sustainability, renewable, reinforcing the renewables for the only ways in which our climate can be saved and we can be living in a sustainable environment going forward. That's why there are several initiatives, whether from the electric vehicle space, solar space, green hydrogen, etc., which we all must, as lawyers or even as individuals, be aware of. Only then can we remain relevant in times going forward. When we talk about AI or digital space, there is a clear focus or concern around privacy. That's why you will see a lot of increased regulation around data privacy and good corporate governance. And in the background of COVID, as you all know, pharma sector along with healthcare have seen a considerable exponential growth. Next slide, please. When we talk about the art of drafting, there are key contract protections that you may want to keep in mind. And for this, I would want each of you to, just a second, go to your next slide and type in menti.com, the code 19274196. What are the points to be considered while drafting a document? Let me just share my screen. Let's see what you all have inputted. Being effective, being to the point, having precise language, very critical to understand the case, be coherent in whatever you are drafting, formatting. It must be backed by knowledge of law, being an expert in the subject matter which you are dealing with, the essentials of the transaction must be known. Right, you all are bang on point. I think now we can stop here and we can proceed to the next. When we are talking about, yes, next slide, please. The art of drafting. The points to be noted are that there must be a clear understanding of the scope. I think all of you clearly understand that we must know what is it that we are dealing with, what are the client's requirements. We should be aware not only of the facts, but also of all the entire scope and what background the client has, whether he is from the buy side or the sell side, which industry does he come from. Come to the point, always use active voice when you're drafting. While we would always want to protect the interests of our client, but please prepare a win-win draft because that will be considered reasonable. And whether it is before the Competition Commission, if your agreement or transaction goes, they will look at clauses which are tailored and just balanced, would be something that would save you. But if they are tilted towards one party, then that is something which would be looked at very closely by the regulators and not looked at favorably by them. So please ensure that you have a win-win strategy when you're drafting the document. Obviously, that cannot happen when you're dealing with pleadings, but here we're talking about contracts. So while in pleadings, as well as in contracts, you have to first protect your interests, the interests of your client, but always try and keep the second fallback and other negotiation points that you may want to give away as subsequent rounds of negotiation. Please avoid any technical jargons because anybody who's looking at a contract is going to be a layman and will want the simplicity of language, will avoid any interpretational issues later on. You all have rightly mentioned the laws which must be known, whether it's contracts, Companies Act, Stamp Act and registration when you're finally executing the document, Constitution. Obviously, whether it's page numbering, clause referencing, the source, the citations, everything needs to be synced in that document, including the font and the spacing, double spacing, which is usually used. But always understand that there is no perfect draft. The drafting skills are always mastered over a period of time. So even if tomorrow you enter the profession and you find that your initial pleadings or a particular contract draft that you submitted has been redlined and butchered all over, please don't get disheartened because one is the skills to draft and the other is the fact that every human being would draft the same document very differently. So I'll delve on those details separately on the different personality types, different negotiation styles, and different facets that different people would want to draft it differently by. But that being said, there are some very key principles which we would want to ensure that we do not miss out. So whether it's defined terms and uniformity, so that uniformity is extremely critical. Next slide, please. When we're talking about the customer or the client that you're dealing with, you have to understand which industry or sector he or she comes from, which products or services are being offered, because all those specific sector specific laws are also something that you would want to review and know at the back of your palm. Always first understand before you pick up the pen to draft or open your laptop to draft the document, understand that whether you're representing the sell side or the buy side, each party would have different concerns. For example, liquidated damages clause is something that a customer or a buy side would always want to include, while a sell side, even though they cannot always resist it, but may want some specific points to be covered in that clause. For example, they may want the starting of that liquidated damages to start at 0.5% of the delayed portion, as opposed to the entire value of the contract or a percentage of that. So if only one particular order has been delayed, you only want maybe 0.5% of that to be as an LD starting point, and then want to put it as a cap of 5% or 10 times or 20 times, depending upon what the parties are able to negotiate. But always understand that even if you're from the customer side, don't try and include an extremely exorbitant amount, because like I mentioned, if it's too harsh, then courts would also look at it as if it is not a liquidated damages but a penalty, and therefore hold it as null and void, and then they would arrive at a more reasonable analysis. So when you're drafting, please try and ensure that you keep those considerations in mind to ensure that the draft is very reasonably worded. The scope must while it is exhaustive, but it must ensure there is no scope creep whatsoever. So any terminology like etc. or including but not limited to, or any other scope that the customer may require, and just leave it open-ended like that, should not be accepted. It should always be tied back to some specifications document, and so on and so forth, so that the scope is very clear and tomorrow there is no interpretation or any conflict there. When you're talking about the territory, sometimes it could be limited to specific states. In India, it could be the global territory. And in such a case scenario, you may want to be specifically particular about your product or services and which countries or states does your product go to the end customer, because you may want to ensure that you're compliant with those specific laws as well. So your product's compliance with those global laws is something that you may want to take care of. Something as basic as data privacy in different areas. While Europe may have the GDPR, in India, you may have a different requirement, and so on and so forth. So I would suggest that these aspects must also be looked at. Finally, from a tenure perspective, if it's a perpetual contract, then obviously the risk is much more, but ordinarily you would see a specific term, and the survival obligations is also critical that you may want to look at. Next slide, please. While I'm not dealing in detail with all the contract specific clauses, because that would be an overkill for this particular presentation, but some of the critical clauses I've just covered, which are maybe from a warranties or liquidated damages, indemnities, the protections that would be in addition to that. So take, for example, if we just delve in detail on warranties. There would be fundamental warranties relating to your ownership and title. There could be the business related warranties, which would be related to the financial condition and compliance with relevant laws. There could be specific warranties or representations on anti-corruption and bribery. Finally, there will always be tax related warranties. Why I've divided them into these 4 topics is because each of them have different time limitations or monetary caps that you may want to enforce. And usually the fundamental warranties would be uncapped and may not necessarily have a time limitation. On the other hand, when it comes to a tax related warranty, you may have a 4-year period for the timeline for the limitations. Similarly, when it comes to the monetary limitations, they could vary for a business related warranty anywhere between 20% to 100%, depending upon the business agreement and the commercials that have been agreed and negotiated. So it's also a part of the negotiation strategy. While I don't want to go too much into detail on the baskets and de minimis provisions, since that may be a little bit too detailed for you all at this stage, but I would still expect you all to know and understand that de minimis in an indemnity provision would be the bare minimum threshold, and below which, can you go back to the previous slide? Below which you are not going to be liable to pay. Usually a de minimis provision would be a 0.1% of the total liability or indemnity. And a basket concept basically means that until and unless your claim or the loss of the customer X amount of threshold value, take for example $1 million, until and unless $1 million threshold is reached, the liability to indemnify the other party would not necessarily arise. But from a baskets perspective also, there are 2 different kinds of baskets.
Hello.
Hello. Yeah, now can you hear me?
Yes, ma'am.
Yes,
Sorry.
ma'am. No issue.
I think someone would have pressed mute. So going back to the last point, when we talked about the baskets, you need to ensure that the bare minimum threshold value which is mentioned in the basket is going to be covered, or anything over and above is also going to be included in your indemnity clause. In the qualifiers, you may have a knowledge qualifier which says that only if the person had knowledge of that breach at the time when it was committed, or to the extent that the breach is material, would it entail an indemnity obligation or a liability claim. Similarly, if there is an obligation to comply with any specifications, etc., or with respect to reporting, it may be something, or just supporting the counterparty. You may want to add words like reasonable support, because you never know how much commercial impact a particular claim or support may even require. Finally, there could be the LD clause, like I've already dealt in detail. I don't want to repeat here. There would be the indemnity, which is obviously purely contractual, and you may have always be required to put a mitigation obligation that the party who is coming claiming for an indemnity must do everything under their control to mitigate the losses. As you're aware, there would be monetary and temporal caps to this. When we talk about a parent guarantee or surety, there could be some comfort letters which may be provided. There would also be scenarios where WNI insurance or warranties and indemnities insurance or a representation and warranties insurance. These are very common in today's M&A transactions. So you can be rest assured that you will come across these clauses as a corporate lawyer. When there are any guarantees, there could be some amounts which are extremely critical. You may want to put them in an escrow and hold it back to ensure that some regulatory compliance or restriction or some penalty is fulfilled. So these are some initial points that you want to consider. Next slide, please. Hello. Yeah. So when we talk about some of the other critical clauses, we have the most favored customer clause, which basically entails that the lowest price should be offered. Here, as a sell side, you may want to limit it to specific products, or you may want to say that I will give you the lowest price subject to the fact that other customers have the same products, have the same volume of, have the same terms and conditions of the agreement, are operating in the same territory, so on and so forth. Because the more restrictions you put in these conditionalities, the lesser are the chances of the claim coming in case of a breach of the most favored customer, or the MFN, most favored nation clause, as you call it. In case of a default of this clause, usually you have to pay the lowest amount which is paid, which is not given to the customer up till now. So the refund or matching that amount is something that you may want to make good. When we're talking about non-compete and exclusivity, why I'm putting them together is that usually these kind of clauses are negative covenants, and even though exclusivity may be framed in the form of a positive covenant, it may have negative obligations which are flowing from it. So the Competition Commission or the antitrust laws would kick in place if you draft something which is either covering too much of a time period or is extremely harsh. I would suggest that these kind of clauses should ordinarily be limited for the duration of the contract and for a reasonable period outside that. There's a clear exception for goodwill, because when in an M&A transaction, a particular company is acquired along with their goodwill, then the non-compete clause is considered to be a reasonable restriction. When you're talking about exclusivity, I would suggest that you include a minimum purchase commitment, because that is comparatively a lesser evil, and always try and limit those exclusivities to some specific territory, products or services. And when whether it is exclusivity or a benchmarking exercise, never try and put any general overarching language like a comparable industry, market, so on and so forth. Always limit it to the specifics of the scope, of the specifics of the price. So you could have a price benchmark, you could have a technology benchmark. So I don't want to go into too much detail, because those are things which we can deal with in separate presentations and training sessions. And I would also request you all to use this as a time to go back and research on additional topics that you hear about today, because that will help you in the course of your career. When we're talking about dispute resolution, obviously it should be preceded by an amicable resolution mechanism with the time period. Then if you want to avoid this going to the courts, usually it's always a good deterrent to include an arbitration clause, as we have been seeing to be the norm. Because of the high costs involved in arbitration, parties usually like to avoid making it too litigious or going to court too often, because the arbitration would eventually not be financially beneficial for them. Obviously, you'll include the basic points of the venue, the language, the fee share of the parties for the arbitrator, whether there's one or two arbitrators and third being mutually appointed, what rules of arbitration would apply. When we go to confidentiality, you need to understand that the two parties must have a relationship which is existing, because with the third party who is unrelated, you cannot enforce any form of confidentiality obligations. It is only because the information that you're sharing has commercial value that confidentiality obligations can be enforced therein. Usually that may have a 3 to 5 year period, and may have a survival period again of 2 to 5 years, anywhere in between. However, when we talk about trade secrets, they usually have a term that they remain till as long as a trade secret remains a trade secret, the confidentiality obligations shall continue to survive. So these are some points that you must keep in mind. Again, confidentiality obligations, since these are negative covenants, you need to ensure that it is not one-sided, and specifically if it's considered to be a restraint of trade, then it will be striked off by the court. So these are some critical points from a drafting perspective that you would want to delve into. Next slide, please. As part of the negotiation skills, I would want all of you to again open Mentimeter and go to the next question, which is available in front of you. What do you understand by BATNA? I'll share my screen to see exactly what you all are inputting there. Please don't feel shy. Even if you don't know what this means or what this terminology refers to, please give it a shot. The code you have to enter is 19274196. Log into menti.com, www.menti.com. So what is BATNA? Yes, someone saying win-win situation, best alternative to a negotiation. I like the fact someone is being so upfront by saying not aware, because that there is never ever any point in being shy to admit that, okay, if you're not aware, you're here to learn. And that's why they say there is no wrong answer. You're here to learn. So let's now try and see. Negotiative agreement. Okay, no worries. So now when we talk about the next slide, we basically have the negotiation skills in front of us. BATNA means a best alternative to a negotiated settlement. I will deal with this more in detail. And what I would suggest is that you all can also go through these details at your own level. That will help you tomorrow in understanding the negotiation skills better. First and foremost, from a negotiation perspective, like I mentioned, preparation is key. Even before you enter into negotiation, please get all your ducks in a row. Step into the shoes of the counterparty. Try and understand what would be the critical points from the counterparty's perspective. Even if you're a seller, you may want, okay, you want to limit your liabilities, you want to cap your indemnities and liabilities, you don't want too many LDs or penalties, so on and so forth. On the other hand, try and understand that the customer may want that there has to be a seamless flow of the supply of the services. So if there is any case where you're either going to say that because of any escalated price and no agreement, mutual agreement, you can walk away from it, or there is a termination for convenience. These are things which a customer who would want continuity would look at very closely. Or even if you're keeping some force majeure right, because of which your supply is going to be delayed, as well as a suspension right. So step into the shoes of the other party. You may always know what yes, Ritik is saying, what is our product and what are we offering? That's exactly what you need to know at the first instance itself. And only when you know that, you need to understand that, okay, what is it that the counterparty will be asking for? So take, for example, you're dealing with a telecom related contract. Then obviously the continuity of that telecom supply or the services that are being offered is going to be extremely critical. And the same applies even in an e-com sector. So the replacement, when you're purchasing something online, the replacement needs to be done as per the law. Or if there is any data breach, then what is required? Obviously, yes, I completely agree with Dakshita that you should not tell the other party what your BATNA is. But I would also add one point that you should prepare your fallback and walkaway positions and several rounds of negotiation, what that drafting change which you can give away to the other party, you should prepare that in advance. Because what happens is that in such a case, whatever you're asking for may not necessarily be given at the first instance. But what you need to be prepared with is that even if this is not given, then how can I tweak this language so as to make it more acceptable to the counterparty? Or in other case, if no modification is permitted in this clause, is there some other clause that I can get in lieu of this clause so that it is mutually beneficial for both the parties, like I mentioned, in a win-win situation? So that's what developing a MISO means. Multiple equivalent simultaneous offers. You must have that, okay, if this is not accepted, keep that as part of your preparation for the negotiation draft, for the negotiation exercise where you are end-to-end negotiating with the end customer, or even you are giving to your client so that they can use that as tips to negotiate subsequently. You must come up with some creative solutions. I'll give you an example that while everyone would want that the products or services should comply only with the specifications, but several times the client says that anything that is merchantable or fitness for purpose, now these kind of warranties should never be accepted by a supplier. However, when you're dealing with a customer who is maybe the tier 1 customer in that particular field, then he or she may not necessarily accept a clear deletion of that. How you can modify or redraft this is that you can maybe provide a specific definition to mercantile. You can provide a specific definition to fitness for purpose, which may be linked to the mutually agreed specifications, samples, acceptance tests, so on and so forth, because these are things which are in our control. But take, for example, you may be an ingredients or a raw material supplier in a very big automobile or in a very big manufacturing space. In such a case scenario, you may not even necessarily know where your product is going to be used by the end customer. It could be in a electric vehicle, battery fitted electric vehicle. It could be in a robo. It could be in a drone. I mean, now with AI and 5G, everything is now open. So you don't know what the end use would be. In such a case scenario, mercantility and fitness for purpose would be very different from what you think. You may think that, okay, I'm giving this particular equipment or raw material to serve these so and so acceptance tests which it has cleared and as per these specifications, but the end use may be very different. So understand these points, prepare your strategy accordingly. Be very particular to overcome any biases, whether it is a cognitive or a cross-cultural bias that may be there, and because that becomes a hindrance to an effective negotiation. Next slide, please. When you're going looking at the negotiations styles, there are five different negotiation styles which will vary not only from person to person but also be dependent upon their personality types. While we cannot delve into thorough detail on everything, but I will want to focus on these five. So when you're talking about collaboration, ideally collaboration is the best way forward because this would entail a win. This is an integrational kind of an approach. On the contrary, when we have a competition kind of a negotiation style, that would mean that I win, but you lose. This is a dominant kind of a style. But I must tell you that each style would need to be applied at different stages as per the requirements during the course of your negotiation. Obviously, I'd want to keep avoidance at bay unless, of course, there is something which you don't want to reveal to the counterparty. But usually, take for example, it is very important that for some clauses which are a clear no-go for you. Take for example, if there is a indirect consequential liability or if there is an uncapped liability, you may clearly want to put ahead your competition kind of a negotiation style that this is just not acceptable because of XYZ reasons. We don't know the exposure of indirect consequential and obviously there could be incidental, special, punitive damages. You may want to be very clear on this point. In addition, obviously you don't want that the negotiation falls flat because of this. So what is required is that you try and give something in return. Usually the client may say that, okay, this is a no-go. And then as a compromise, you may want to go for win-lose, means that, okay, I am willing to give up, that I will not make my force majeure clause as detailed and as elaborate as I wanted it to be, with outlining each and every event. But I may have 4-5 events and then maybe say anything else outside my reasonable control. And in lieu of that, you give me maybe these points relating to a capped liability or indirect consequential damages exclusion. So these are some points you must keep in mind, that what are the critical points for you and what are the critical points for the counterparty. That's where the BATNA and MISO different options would come into place. Obviously, there is also the avoidance kind of a style, which is never really recommended because both parties are there to lose. And this is when you're just neglecting or avoiding a point of concern. It's always good to be transparent. But that being said, there is a way and time to bring it to the table, and be very careful when to bring what to the table. Take, for example, we were negotiating recently with the tier one automobile manufacturer of the world, and there they were very particular. We got hold of, they were very particular about confidentiality and not disclosing the name of their the fact that we are negotiating with them out in the market, because that leads to sufficient upheavals in stock prices and so on and so forth. So even though we got access to a corresponding competitor and lead tier one suppliers contract which was available online. So we know that from a confidentiality perspective, that was already available online, because that was required by the regulator. But we first and foremost tried to align, we tried to understand that obviously some things would be redacted, we do not know the value. But that being said, there are some clauses which you can use as part of your negotiation. There are some stages when you feel that you have reached a dead end, you may want to bring it to the table, that we understand that you have negotiated so and so clause with so and so person with and but that should only be the last resort. Usually try and do this without actually naming, and try and ensure, because you know that whether it's the business team or it is the legal team, they would be something that they have accepted in the past, they would be more open to accepting that now. So these kind of knowledge and research that we had done, which gave us access to that document, really helped as part of our negotiation. Next slide, please. Now, when we are talking about the negotiation styles, it will each negotiation, I'll tell you why we need accommodation. That's a good question that has been raised by Nitendra. Uh, I'll tell you why. When we are talking about, in some cases, you may want to let them know that, listen, you may want to tell the counterparty, I am open to giving you this. However, in return, so what will happen is that you're actually appeasing them and accommodating 2-3 concerns of theirs. In return, you may want to also pitch your competition style and say that, in return, I would want so and so. Eventually, you will move towards a collaborative style. So in the first instance, your your counterparty will be very happy that you have accommodated and appeased him or her by giving or accepting some of those clauses. Take, for example, for you, it may not necessarily, you know that the prices are more or less stable, even though you do not get a year-on-year escalation with the inflation. But as long as you are able to mutually agree, you are going to be fine with it. So on the other hand, the customer, if every year there's going to be a 20% escalation or inflationary indices and all that are going to be included, then tomorrow the business person may find it very difficult to go back and get that approval. At that stage, you may want to, you understand that as long as it is mutually agreed, and if tomorrow, take for example, market rises and there is no mutual agreement, then you either have a walk away right, or if it's convenient, then and there's not too much of a deviation, then maybe you can arrive at a mutually agreed formula, so these are some kind of accommodations that maybe you are not insisting on an inflationary index or indices that needs to be specifically outlined, or even specifically saying that a price erosion every year of this particular product by 5%, 2% would be there in this equipment. Even though you're not insisting on something like this, which a customer may want to insist in some cases, but in return you may want to ask for something else. Like a customer may want that, okay, if you delay the payment here, if in a particular industry he feels that payment delays are very common, so he may want to put a payment delay having a late payment interest clause, or some other kind of a termination linked with that, or any other penalty. Another point that Mohitisham had mentioned is that start with a lower value to be settled in the middle. And And this is very true for any negotiation. If by chance you have got an approval internally for a 10%, please understand that if you're going to put 10% as your first response, then you're not going to be, that's not going to be your walkaway position, because the counterparty will always negotiate it further. So always, if you've got an approval only for 10% and you cannot go higher, then start much lower so that you have leeway for negotiation and coming to a final response. How can competent style be more assertive even if it erodes the relationship? Here, I'll want to say one more point. If it's tomorrow, see, if tomorrow we are saying that, here I would suggest you look at both these options that I talked about, that ordinarily collaborative is the most beneficial kind of a style, because that will not only help in getting better outcomes because it's a win-win strategy, and the other way where we are talking about the competent or dominant, take a step back and give you an example. Take for example here, going back to that point on uncapped liabilities. If tomorrow you have clearly said that I cannot have either indirect consequential damages exposure, because today my particular product is an ingredient and tomorrow it could be used in a robo and God knows where, I don't even know its usages. So I need to ensure that it is capped, one, and secondly there is no indirect consequential damage. So here I'm being dominant and I'm trying to I'm displaying a competing kind of a negotiation style. However, when I'm doing this, if I try and in line with this also give an accommodation, ideally because you're being assertive, this may not necessarily lead to a relationship improving, subject to the fact that if your reasoning is something which is logical, that's why we say you have to go prepared. Every term, every clause, every word that you have in a contract draft, in a pleading, you should have logical reasoning for it. If you can substantiate it with substantial reasons why this would be completely unreasonable to ask for by the other party, then it will actually help in improving the relationship, because he or she will actually come back to you and say, see, I completely understand your point, however I don't have this, maybe I can do so and so in return if you give me so and so. That's where you will appease him and then move together. So because you started with a competent dominant mode backed by a logical reasoning, please understand, just saying no for the sake of saying no is not going to work in any negotiation, just like it doesn't work with parents. You have to back it up with some reasoning. Just like any relationship, you can't just negate it for no reason at all. You have to have very logical, reasonable considerations, which the opposite party will also consider as being very right in your stand of having even raised it. Because I'll tell you, if you don't raise it, tomorrow the same counterparty in another transaction, maybe because everybody sometimes is switching jobs, sometimes you may be negotiating from the other side. When he or she knows that what is critical for a customer and you back it with logical reasoning, and then try and give something in return in order to ensure that your critical dominant must-haves are protected, they will respect you and they will value you as a relationship, as a competent person in your particular domain. So that's where the relationship improves, only when you back it with logical reasoning. Obviously, it will not improve if you're just going to deny it for the sake of arguing and saying that, no, sorry, it's not acceptable, I have no reasoning for it. That doesn't work in a negotiation. Okay. Going back to the next slide, I think we've come back because now let's talk about the personality types. Usually, the negotiation styles are very much dependent upon each person and every negotiator's personality. Take, for example, an individualist would ideally only be looking at my own win, irrespective of what concerns the other party would have. On the other hand, when you're talking about a cooperative kind of an individual or a personality type, they would want to not only maximize their own interests, but would also want the counterparty's interests to be secured. In such a case scenario, the cooperative personality type will usually move towards a collaborative negotiation style, right? Similarly, when we're talking about a competitor, you may find a competitor kind of a personality type very similar to an individualist. But I would like to even let you know that there is a slight difference, because an individualist is only interested in maximizing one's own outcome with little concern for the others. However, a person who is a competitor kind of a personality, while this is also a predominant area of a competitor personality, but they are more interested in trying to see how much of a gap do I have vis-a-vis my competitors. So if the gap is more, then that's something that they want to maximize. So that's where the slight difference between a competitor personality type and an individualist personality type arises. And finally, we have the altruists, who are basically happy with giving away or appeasing the counterparty. Like we mentioned, in some cases, it may be good to have the altruist in order to get something else in lieu. So while you may want to give something in return, so it is good to appease, but be very careful that at every stage you don't give up so much that in the subsequent round you have nothing else left to give. Always keep in your hand something or the other which you are willing to exchange in lieu of something else. And you must also understand, when I'm telling about the preparation, put the value against each and every clause, that this particular clause, does it come high or critical in my consideration, as well as the counterparties. It's possible that it is critical for me, but for the counterparty it may be of medium significance. Because take for example, he may be a business person, he may not necessarily be interested in the indemnity clause as much as he is interested in maybe the price and the supplies being continuously provided. Or he may want to insist, on the other hand, if it's a legal person you're negotiating with, then indirect consequential damages may be very high on their priority. So you have to always understand what is important. When there's a question that Mohit has raised about altruist and compromise. Yes, a compromise kind of a personality to some extent is common, but because actually to a lot of extent, because usually an altruist person is going to be appeasing or accommodating, and that is going to be more with respect to a compromise. But there is another scenario that here it could be a scenario, there could be slight differences. So in some scenarios it could be a compromise, it could be another scenario where you're altruistic but you're in something else trying to get, and then eventually you're moving towards a collaboration. So you need to see where exactly this is being placed, so that just because you're giving up something, you shouldn't be in a compromise position. But always understand, in every negotiation, at some time or the other, you need to give up some clauses. Always try and see whatever maximum which is going to have a risk and a cost exposure. There could be some clauses, take for example, we lawyers, and this I'll give you practical information, that we lawyers spend considerable amount of time negotiating the limitation of liability, indemnity, warranty clauses. However, when you see actual practice, usually what gets negotiated or goes into disputes the most may be a liquidated damages clause. It could be a force majeure clause. It could be a dispute resolution, because those are the ones which would actually kick in at that stage. So it's very important to understand that even though you are negotiating, yes, this may have a high risk exposure, but also try and see that is it going to be as high in terms of, is it going to be going to court? Are the chances and probability of that event happening high or low? It's possible that a particular product is not meeting the requirements of a particular test which is required. And you know that, therefore you're fighting it because you will get stuck. So the probability would be as high as the risk. So always do this calculation in advance. Next slide, please. Now, I understand it's been pretty heavy. So from a management skills perspective, before we get into the mentee question, there are three broad kinds of heads from a management skills that you would want to keep in mind. The first is with respect to the technical skills. A manager or usually is management skills or the leadership skills are usually intertwined and used interchangeably. However, not every manager would be a leader because you need to exemplify and live those qualities day in, day forth, day in and day out, in order to get and earn the respect of your people and then qualify as a leader. Nevertheless, if you are a good leader, you would invariably exemplify the managing skills, despite the fact that you may not necessarily go into the nitty gritty, because at a high management level, you may have the right to delegate. From a technical skill, coming back to the broad heads, technical skill would be maybe with respect to the products, the services, the machine usage, or even with respect to the skills, marketing skills, which would help you to boost the sales, or even design something very different. So these are the technical skills which are required by a manager or a leader. When we go to the second, which is the interpersonal skills, these are very critical because these are the human skills. This would ensure that you have the ability to interact with people, build an empathize with them, and build a more humane environment in which your people can work. Only in such a safe space would the human potential be to the maximized level, and you would be able to gauge the better results. Finally, there are the conceptual skills. The conceptual skills are more with respect to the ideas, the concepts, the abstract thinking, or some creative solutions, diagnosing some problems. So the problem solving ability is also something that, whether as part of the management skills or leadership skills, that you must have some creative conceptual skills that you should try and inculcate. Next slide, please. Let's go to Mentimeter. And here you can see the next question, which is available in front of you. We can now see what are you, please try and include what are the qualities of a good manager or leader. The code is 19274196. Does he show empathy? Is he a good listener? Is he or she decisive? Is he a good communicator, or takes responsibility and is accountable? See, there are no one right answer, so feel free to put whatever you think is the most appropriate and as per you, which is the most important quality of a good manager or a leader. Please log into www.menti.com and use the code 19274196. See, we would want all of you to participate.
Ma'am, it's showing closed.
Give me a second. Now, can you see?
Yes, ma'am.
Yeah. Great. So communication, good listener, being decisive, taking responsibility. See, all these are critical. Each person will want to respond in different situations. All these qualities would need to be exhibited. Very good. We have quite a few results now. So I'll just close the voting now. And going to the next. As part of our effective management or leadership traits, you all rightly mentioned that all of them, and yes, Ritik has rightly mentioned that all of them are correct, and therefore you would need to exemplify various values or traits or skills at different points in time. Uh, in case of a conflict situation, when in an immediate decision making or problem solving is required, then obviously you will want to exhibit that. In cases where there is a communication gap, then you may want to be a good listener. You may want to ensure that there is proper communication. Obviously, if anything goes wrong as a leader and a manager, you must, as a very basic point, be accountable and held responsible. So irrespective of the fact that you may have delegated the work, just because something has gone wrong doesn't mean you start putting the blame on others, because a leader or a good manager is one who stands up for the team. So that's where the teamwork comes into play. And you have to keep the long-term goal of the organization in mind, because just taking that responsibility as of now does not make you smaller. On the other hand, you will win the trust of the team that you have stood up for them. And tomorrow, obviously, it is your duty to do that root cause analysis and try and understand what went wrong where. So, most importantly, you have to be self-motivated, because only then can you actually motivate other members of your team. And next slide, please. If we delve into further detail on these management skill sets, there are quite a few, and even though this slide mentions several skill sets, they may not necessarily be the complete set. While obviously planning is required, training your team and organizing them is very important. Time management is extremely critical for a leader or for a manager. You need to develop not only your team but the organization as a whole. So you keep the long-term interest of, first is the short-term interest of that particular product or that project, and then the long-term interest of development of the organization and your people who are working with you as a whole, so that everyone grows together. Obviously, keep in mind the strategy. Human resources, like I mentioned, that human element is important, as is also innovation, because as we know, change is going to be a part of the new norm now. And only when we continue to evolve and innovate will we continue to be relevant going forward. So we need to come up with creative solutions, create values, and think out of the box. But just because you want to think out of the box doesn't mean you go against the main course. Always ensure that, one, you don't have to be scared if you have a contrary opinion, but that should be backed by something very reasonable and something very logical, to the extent that that is something that you have thought through, and you're not just saying out of just being different kind of a style. That is something, when it's well thought out, planned, that it will be fruitful. And always ensure that you take the team together. So teamwork is critical. You need to guide them and communicate and leave all communication channels open for them. Next slide, please. Now, these are some points which a particular manager or a bad manager would display, or some traits which you should be wary of. So one side, you should know what skills you need to inculcate. The other side, you should also know what is it that is not good for the team or you as a leader. One, you cannot be indecisive. You must never be bossy. You need to take the people together. When someone is coming up with a different idea, don't ever dismiss it, but because you never know that what particular idea may set the ground for a growth or a new opportunity for the organization going forward. And just because you are maybe from a personality type who likes something to be steady doesn't mean that you are averse to change. Always be open to it and do a thorough planning. Be consistent in what you say and what you practice. That is something that all leaders and managers must always include in their personality, that no matter what happens, your practice, you must always practice what you preach, because otherwise you will not be able to get the trust and respect from your employees or from the organization or even from your seniors. They should be able to understand that you are authentic, you're true to what you say, and you are reliable. Next slide, please. I would again request you all to, this is towards the end now we are approaching. So this would be the last mentee question. Please log on to mentee.com. Here, now the voting is open. Please use the code 19274196 and try and let us know which management or leadership style you would use. Let me share my screen to show what results we have. Most of the people are willing to use the democratic leadership style. Very good. 48% of you have chosen to use the democratic leadership style, 50% now. And there are still additional polls that we are getting. Super. So as we can see, this is the best way to approach, give me 1 second, to approach this scenario. Going back to our slide, from a leadership perspective, you must be democratic. And like 50% of you have mentioned, this is something that you all must exhibit. Now, towards the end, I would want you all to identify your own personality type. I understand there is paucity of time, so I may not have the time, unlike what Ritika ma'am had wanted, that I should do a 1 or 2 days conference. Maybe in that, I would have actually helped you all understand your personality type by going through the DISC test. DISC test basically entails where each person can be broadly defined as either falling under a dominant personality type, one who is strong-willed and is moving as on a fast pace, but is still skeptical of others, likes to direct people, or it could be an influencer kind personality who's very sociable, talkative, and lively, but still is fast paced. The difference between dominance and influencer would be that an influencer is more sociable and is more accepting, as opposed to a dominant personality type who is going to be skeptical. When we talk about steadiness, usually a person who is from a steady personality is usually more gentle and accommodating and soft-hearted. They're usually moderately paced and are accepting of others. They are not as skeptical, but they like to lead their life at a more moderate pace, but accommodating. Finally, there could be the conscientious type who believe in analyzing and presenting every view in a very methodical and a logical fashion. They are extremely private. However, as opposed to the steady personality type, the conscientious are skeptical and not really accepting others as the steady are. So while the first two, the dominant or influencer, are fast paced, the steady and conscientious are moderately paced. I would also suggest, whether as an individual or as an organization, that you may require to do subsequently in every problem solving situation, or even in life while analyzing yourself, you should perform a SWOT analysis. SWOT, SWOT, as the name stands, is basically an analysis to understand the strengths, the weakness, the opportunity and threats in each of the scenarios. And even with respect to your own personality, you should be able to do that analysis and try and see that you can use your strengths and advantages in your favor, and also be aware of the weaknesses and threats that whether the organization faces, your team faces, or even at a personal or individual level that you are confronted with. When you are aware of the weaknesses and threats, maybe you can find out some strategies to work past them. So there are quite a few action items, or I would say homework, that I have given you. Maybe you can take this DISC test as well as the SWOT analysis and try and see in which category do each of you fall, so that tomorrow, if you want to develop the other skills, I would always suggest that there are good points in every aspect, but obviously in a negotiation, always move towards a win-win, always move towards a collaborative and a cooperative style, but try and ensure that both sides, even though it may not be the best case scenario, but like we mentioned, the partner or the best alternative should be taken into consideration. I think when you inculcate these values, and like we had started with Stephen Covey's 7 habits of highly effective people, if you inculcate those habits in your day-to-day life, then there is nothing that can stop you from being more successful, not only a corporate lawyer, but also in any other domain that you may want to excel. So these are the broad points that I would want to cover as part of our presentation today. Since the topics were so wide, I have thus given you some additional homeworks for additional tests that you should conduct to understand yourself better, because that will help you in building a strong future going forward. So next slide, please. I think we've reached the last stage. And after the disclaimer, I think it's just towards the end. Next slide. That's about it. If you have any other questions, in addition to the ones that we've already answered during the course of our presentation, please feel free to share them. I'll be happy to take any questions. I was conscious of the time that we had that was constrained, so I'd limited it to this time. If there's anything else, the team has my number. Feel free to reach out and I'll be happy to guide you.
Thank you so much, ma'am, for this insightful session. I believe we have come to the end of the session with this. If anybody has any questions, we can probably take 1 or 2 in the next 2-3 minutes, provided ma'am
I
has.
think Ritik is asking for my salary. Well, that I think we can just let it be for just now.
Okay.
We have, because I have almost 2. Yeah, sure, we can connect on LinkedIn. Feel free to reach out. I'm accessible on LinkedIn as well. So I would just say, just don't be wary. Because in the course of these 2 decades, I have seen lots of things change, and having the background of both in-house, law firm, litigation, outsourcing, you name it, I have done it all. So if there is any kind of specific queries that you have, please feel free to reach out. And there is no perfect or right for everyone. Everyone may be comfortable in a different setting and space. As long as you have these skills, I think you can excel in every space.
Absolutely. And I think it's time for us to put these strengths and weaknesses and also analyze ourselves in the process, and also put all these learnings that we have gathered in the session today into practice in real life. And like ma'am mentioned, there is no perfect draft, And I believe there's no end to learning as well. And we look forward to having you again with us, probably for a physical offline session in the coming months. Right. So with this, we have come to the end of our session. I would request everybody, whoever is comfortable, to switch on their camera so that we can take a screenshot of the session.
I think we also have one last question, that what are the qualities that Khaitan looks for?
I have a question.
Primarily, the qualities are the same. Obviously, in every team, there is no shortcut. So the knowledge, there is no shortcut to the knowledge that you would need to gain and study and learn. So that's something I think you all should, irrespective of the team or the specialization that you're looking for, you would need to have. In addition, all these skills that we've mentioned would be extremely critical. In a corporate side, obviously, the M&A, due diligence related, and the contract drafting or the transaction documents drafting is going to be extremely critical. So these are just some of the points. Obviously, on a case-to-case basis, it could vary with the different teams. Thank you.
Thank you so much, ma'am. Also, one of the students asked if you could share your presentation, if it's allowed for us to share the presentation with the students.
Sure. I'll share the presentation. I'll just make a modification and I'll share with you. Maybe then you can share with the team.
All right.
The PDF version. Sure. I think Ajit has a question.
Yes, ma'am. A very good evening, ma'am, and thank you so much for giving your valuable time to us. So, ma'am, at this moment, especially for the last semester students, what is your advice for them? Because in coming times we are going to appear in so many interviews and for jobs. So, what's your last 2 cent advice for us, ma'am?
See, what I would suggest is up till now, either you should have already completed your internships or as many of them. But God forbid, if any of you have not, or for some reason have not been able to, I would still say, see, it's never the end of the game. There is, like I mentioned, there's nothing like a perfect career. There's nothing like a perfect draft. You you will chart your own territory. What is most critical is first trying to understand. I would suggest all the points that I've mentioned in my presentation, whether it is with respect to understanding your own areas of specialization, whether it is understanding your own personality type, each of the things you undertake those exercises now. And then once you know that, okay, these are the 1 or 2 or 3 4 areas that I'm comfortable working in, you can start joining or applying. And obviously you should start doing that now itself, because several times different firms, some take freshers, some would expect that, okay, you come with at least 1 or 2 years of experience. Every place would work differently. But just because you're not getting in at a particular place just now doesn't mean that you have closed those doors forever. So just be hopeful. As long as you're treading this path, you will eventually reach wherever you aim for. Like I mentioned, you need to do that personal mission statement analysis that I covered in the beginning of the presentation. So all these things will help you to understand for yourself where you want to be, and then start dividing that into smaller steps of things that you can achieve each day. Weekly goals, long-term goal, weekly goals, daily goals. And I think this is a lifelong process that of learning that we should inculcate.
Thank you so much, ma'am. Thank you for this insightful advice.
Most welcome. Pleasure. Thank you. Take care. Bye.
Thank you, ma'am.
Thank you, ma'am.
Thank you so much, ma'am.
Thank you so much, ma'am.